Thanks very much, Jen. We are very fortunate to have with us today former Solicitor General Paul Clement. I've had the privilege of knowing Paul for 30 years now, so pardon me for addressing him informally. Hope you don't mind. We first met in the spring of 1992 when I was among those interviewing him for a clerkship with Justice Scalia, for whom I was then clerking. Paul, I don't think I've ever publicly told the saga of how I had to wrestle the justice for days to persuade him to hire another Silverman clerk. But 17 days from now, Paul will make his extraordinary 110th Supreme Court argument as he represents high school football coach Joseph Kennedy in the case of Kennedy versus Bremerton, which Paul's colleague Aaron Murphy discussed on our second panel. No one has argued more Supreme Court cases this century, indeed this millennium, than Paul has, and no one is more highly regarded for the quality of his oral advocacy. Over his career, Paul has advanced the cause of religious liberty, both as a government lawyer and in the private sector. If the arc of the law can be said to have bent increasingly towards religious liberty over the past 3 decades, there's no question that Paul has helped to do much of the bending. We're going to explore in this conversation Paul's role in Establishment Clause cases and in free exercise cases. I'll use the term free exercise to include not only the free exercise clause of the First Amendment, but also federal statutes that protect religious liberty, such as the Religious Freedom Restoration Act, which is, I think most of you know, is known by the rather ugly shorthand RFRA, and the Religious Land Use and Institutionalized Persons Act, which is known by the even uglier shorthand RLUPA. So Paul, let's go back to the start of your career 30 years ago and discuss the terrain of religious liberty back then. Employment Division versus Smith, which got a lot of criticism on the previous panel, was decided, I believe, while you were in law school. Lemon v. Kurtzman, with its infamous 3-part Lemon test that Chief Justice Berger seems to have pulled out of his ear, had been around since 1971. It was not the heyday of religious liberty.
It was definitely not, Ed. It definitely was not. So first, let me thank everybody for coming to this great conference. Your organization and the Gray Center, I think, are a match made in heaven for this kind of conference. So I'm delighted to be part of it. I also want to publicly thank you for not putting the kibosh on my clerkship prospects 3 decades ago. The decision is very much the justices, but I do think the clerks can wrangle a veto now and then. So I really do want to publicly thank you for that.
My story would have been better if there were any truth to it.
Well, there is that. There is that. The Silberman connection did help. But to answer your question about sort of the state of the law, then it definitely wasn't a happy time for sort of religious liberty in terms of the Supreme Court jurisprudence. If there was any sort of daylight, if there was any sort of hope on the horizon, it was that the doctrine at the time was so obviously unstable. I mean, it was the staple of law schools at the time to teach Establishment Clause jurisprudence almost as a humorous interlude between other constitutional provisions, because the doctrine had gotten to the point where maps were okay, but globes weren't, or vice versa, I forget. But it had just gotten to this sort of focus on the minutia, the interior design of creches and whether there were sufficient reindeer were kind of the doctrinal staples of the day. So we have come a long way since then. And as I say, if there's any glimmer of hope, it was that you really couldn't sustain the doctrine of the 70s, 80s, and 90s because it was just internally inconsistent and incoherent.
I was initially inclined to try to track separate Establishment Clause and free exercise developments, but there's so much interplay between them, and in so many cases you see that they're pitted against each other, and you can see a very a view of the Establishment Clause on steroids could leave very little room for free exercise. So I'd like to talk a little bit about that interplay and how it may have changed over the years. Now, one case while you were a law clerk, odd case involved Curious Joel. You want to talk about that a little bit?
Sure. So I think the important thing about Curious Joel, or however you exactly say it, is that it was a case that really, I think, tried to show, from the Justice Scalia standpoint in his dissent, that there should have been a really large sphere for legislative accommodation. I know the Smith decision is most of Justice Scalia's fans' least favorite Scalia decision, and I know that's particularly true here. But one thing that is missed sometimes in thinking about his Smith decision is how much he talks about the permissibility of legislative accommodation of religion. And I think that the Curious Joel case coming, just a few years after Smith, I think he almost thought of it as the legislative accommodation kind of bookend to Smith, much the way Lacumi was a bookend to Smith in showing that there actually were legislatures out there that would facially discriminate against religion.
Let me just interject.
Sure.
This case may be obscure to lots of folks. I should have briefly explained that this was a case in which New York law carved out a school district that followed the lines of a village that was a religious enclave of Satmar Hasidim, if I'm pronouncing that correctly. And the court ruled 6-3, this is 1994, that the carve-out violates the Establishment Clause.
And I have to say, they ruled in that way almost inexplicably. Because what could possibly be wrong with a state trying to accommodate a religious minority by creating a school district that basically mapped onto an enclave where they had a particular religious minority was prevalent, and because of some of the practices of the religious minority, they had some unique needs for public education. If my memory serves, they really took care of most of the children through private schooling, but for special needs kids, they really needed the funding that came with the public school system and the superior accommodations that they had. So it was just this kind of, in my humble view, one of the kind of most kind of humane pieces of legislation emanating from Albany in decades. And yet a majority of the Supreme Court said that crossed the line and became an establishment of religion, which to this day I find a little bit inexplicable.
And of course, our old boss, with his typical understatement, began his dissent. The court today finds that the powers that be up in Albany have conspired to effect an establishment of the Satmar Hasidim. Now, after your clerkship, one of the first cases you worked on in private practice involved Wisconsin's school choice litigation and a supposed conflict between the free exercise and establishment clause.
Yeah, in this case, even more than Curious Joel, shows the tension between the Establishment Clause and the Free Exercise Clause, at least in the eyes of jurists at the time. Because what had happened is that Wisconsin, notwithstanding some of the precedents under Lemon, took this kind of novel experiment in school choice back in starting in the kind of early 90s. And in part because of concerns of the Lemon era cases, the very first version of the Wisconsin School Choice Program was limited to non-sectarian private schools. And that was challenged back in the early 90s on the grounds that that was a free exercise violation, statutory discrimination against religion. And the then Attorney General of the state of Wisconsin, who was a Democrat appointed or elected Attorney General, defended the pilot school choice program on the ground that the Establishment Clause necessitated that overt discrimination against religion. And the idea was, in the argument that the state made at the time, that if we included sectarian schools, even on a non-discriminatory basis, in the school choice program, that would be an impermissible establishment of religion. As a testament to the law at the time, that argument prevailed, and so that challenge to the initial pilot program was unsuccessful. But then the legislature, having seen the success and the promise of the pilot program, decided that they wanted to expand it to religious schools. And they were undeterred by concerns about Lemon and the like, even though at the time those concerns were pretty real given the state of the doctrine. And they expanded the program to include the religious schools. And then the state's attorney general essentially had to recuse because he had already signed all these papers that said if it was expanded to include religious schools, it would be unconstitutional. So turning it around and saying, well, actually, it's constitutional after all, didn't seem like a great idea. So Governor Thompson was then in a position to appoint outside counsel to sort of fill that gap, and he picked Ken Starr, and I was a young associate working with Ken at Kirkland and Ellis back in the day. And then a sort of funny thing happened, which is on the eve of the argument, one of the justices on the Wisconsin Supreme Court recused herself, and that left the Wisconsin Supreme Court with only 6 justices, and the 6 justices split evenly 3-3. So normally when the justices on a high court split evenly, it affirms the lower court decision by operation of law, but this case had actually been litigated under the Wisconsin Supreme Court's original jurisdiction. So there was no lower court case to fall back on, and so under the rules that prevailed, this has happened a couple of previous times in state history, so under the rules that prevailed, it had to go back to the trial court and start over and work its way back up. So if they split 3-3 again, there'd at least be something to defer to. But in the interim, the justice who recused herself stepped down from the bench, and Governor Thompson appointed her successor. Obviously, there was no higher priority for Governor Thompson than the school choice program, so unless he had done a very bad job in judge picking, there was a good chance that if we got back up there, we would prevail 4-3, but we had to get back up there, and there's no way to sort of kind of hit the rewind button and go back on the original jurisdiction. The long and the short of it is we had to go through 2 rounds of litigation, but it didn't matter that much because all eyes were going to be back on the Wisconsin Supreme Court. It worked out great for me because it created an opportunity for a very young lawyer to get a lot of responsibility in the case because the cases really didn't matter that much. They were just setting the stage for the ultimate Wisconsin Supreme Court re-review. So I did get an opportunity to argue the Wisconsin school choice case in the trial court in Dane County, Madison. I remember the courtroom very well because it had all the pomp and dignity of a kindergarten schoolroom. But this very weighty issue was being litigated there, and then did make its way up to the Wisconsin State Supreme Court. The Wisconsin State Supreme Court affirmed the program's constitutionality in a real land-breaking opinion, and then that same issue obviously got back up to the Supreme Court of the United States a few years later in the Zellman case.
Your home state, of course, too, of Wisconsin.
Yes, absolutely.
Now, and what I think in retrospect was clearly a pivotal decision in your career, you left private practice sometime in the late 1990s to become a staffer for Senator John Ashcroft. I also had worked as a Senate staffer for about 2 or 3 years. I highly recommend it. Not for too long, but for a stint. And you were, I believe, chief counsel of the Constitution Subcommittee for him. Now, Congress was trying to figure out how to respond to the 1997 Supreme Court decision in City of Bernie versus Flores. This, as many of you will know, is a decision that ruled that the Religious Freedom Restoration Act, as a matter of Congress's constitutional powers, could not apply against the states. By its terms, RFRA applies to both federal government and the state governments, but the court ruled here that it could not apply against the state governments, and Congress then was trying to figure out what to do, and that fell in part in your lap.
That's right. So the sort of trajectory of this is obviously there was the Smith decision, and then just 1 year after I clerked the Supreme Court, after Congress came and enacted RFRA, the Supreme Court came in with the City of Bernie decision and said that that could not constitutionally apply to the state and local governments. And so obviously Congress had passed RFRA nearly unanimously, and even back then that was exceptionally rare. So there was a lot of continuing interest in trying to do everything that could be done to sort of fill the gap. And it was really the process that was going on when I was there that ultimately culminated in RLUIPA. But we did some hearings when we were there trying to kind of explore the constitutional limits on the ability of the federal government to restore kind of the pre-Smith law as to state and local governments in certain circumstances, kind of using the spending clause in part and the like, having sort of tried using Section 5 of the 14th Amendment and been told by the Supreme Court that that didn't work. So it was actually a really interesting issue in terms of the legislative process, because usually in the legislative process, the problem is having enough votes or having bipartisan support for something. And in this context, that wasn't the problem. The problem was, where is the legislative power to do more to protect religious liberty? And I will say this was going on, I was on the Hill from like 97 to 99, and it's interesting because within a few years after that, you start to see a little bit of this grand coalition that supported RFRA starting to break down at the edges, to the point where now the grand coalition isn't so grand. But back then, there still really was this sense on almost every member of Congress that protecting religious liberty was good government, good politics, all of the above, something everybody could support.
Now we'll talk in a little bit, let's talk some more about the upcoming Kennedy versus Bremerton case. But Kennedy isn't your first prayer at a football game case. You were involved with the Santa Fe v. Doe case that was decided in 2000.
No, that's exactly right. After I left the Hill, because I wholly endorse what Ed said, working on the Hill is a great way to spend a couple of years of your life. The emphasis could be on great, or it could be on a couple. You could go either way on that. But after I had this sort of really pretty clear experience, which is it happened while I was on the Hill that the Clinton impeachment process was going on. And I realized I was a lot more interested in the constitutional issues surrounding impeachment than I was about sort of the typical legislative material that I was supposed to help the senator get through. And that was kind of my signal that, having had this detour, I should get back to private practice. And I ended up at King & Spalding trying to sort of build an appellate practice there. And Ken Starr, who I'd worked with at Kirkland back in the day, was very helpful in introducing me to Jay Sekulow, who obviously many of you know and has become a dear friend of mine. And Jay gave me an opportunity to sort of pitch in on some of his cases. Back then he was litigating in the Supreme Court, I think more often than he has since. And one of those cases was the Santa Fe case. And I think I was on the brief. I helped him sort of formulate some of the arguments. Also helped him formulate the amicus strategy, which I'll mention in a minute. But this was a case where a school in Texas had a program where they essentially created a forum, is the way I might describe it, not the way the majority opinion ultimately described it, but they sort of created a forum for students at the beginning of football games, and the students would rotate through during the year, where they would have the opportunity to solemnize the occasion, which in Texas, I mean, a high school football game is a heck of an occasion, so it needs an appropriate sort of recognition of that. And of course, some of the students, it would be expected, most of them perhaps, would do that through a prayer. But that wasn't required. The student could say something that was non-religious if they wanted to, and as I said, it rotated. So we pitched this as kind of a neutral opportunity for student speech that could be religious, didn't have to be, and ought to be consistent with the Supreme Court's case law, even at the time, in the very late 90s. And we did fall short in the effort in the end, in a decision that maybe one of these days will be reconsidered by the court. I don't think it's necessary in the Kennedy case itself. But part of the amicus effort in that case was, at that time, the only way to win a religious liberty case in the Supreme Court, or really any case in the Supreme Court, was to get Justice O'Connor's vote and Justice Kennedy's vote, which is no mean feat. So we thought as part of that effort, it would be really good to have one amicus brief by a former O'Connor clerk. And so Viet Din was tapped.
The power of reason.
To do that brief. Yes, power of reason. And for the Kennedy brief, we got a then still obscure lawyer who'd been working with Ken Starr on his independent counsel investigation named Brett Kavanaugh to do that brief. So it was a great opportunity to work with some dear friends in an effort to try to get the court to do the right thing.
In 2001, George W. Bush becomes president, ends up selecting John Ashcroft as his Attorney General, and suddenly you're in the Justice Department.
Yeah, lucky me, for sure. When some people ask me for career advice, I say it's really easy. All you have to do is identify who the next Republican Attorney General is, and then you go work for him now, before they're Attorney General. And everything will sort of fall into place. And just to sort of underscore how fortunate this was, I mean, John Ashcroft did not have the most immediately obvious sort of recommendation to become Attorney General, since he had just lost his re-election bid to a dead person. The person he was running against for most of the campaign was Governor Carnahan of Missouri, and he was tragically killed in a plane accident. And then his wife announced that she would take his position if he were in fact elected, and his name was still the one on the ballot. And in a very close election, Senator Ashcroft fell just short, and that did make him available for the job. And when President Bush picked him for the job, I was delighted to have the chance to work with him again, since he had been my boss on Capitol Hill. And I ended up in the SG's office. And I have to say, it was, from my perspective, I mean, what a fortunate turn of events, because when you're a law clerk, you have the opportunity to see the briefing. You're not the justice, but you're still a consumer of legal briefing. And I was so impressed as my time as a law clerk with the quality of the work in the SG's office. And at that time, there were people like Bill Kelly and John Manning and others. Miguel Estrada were in that office, and they prepared excellent briefs, wonderful arguments. And you thought as a law clerk, wow, if at some point I had an opportunity to work in the SG's office, what a great thing that would be. And then to have an opportunity relatively early in my career to not just work in the office, but to be Ted Olson's principal deputy in the office was really an incredible opportunity. So very fortunate.
So you're principal deputy for, I guess, more than 3 years, and then you were Solicitor General for pretty much the remainder of George W. Bush's time in office. So many important cases decided then. Zellman v. Simmons-Harris, the school voucher case I've talked about. Locke v. Davey, on the other side of the ledger, this was a 7-2 ruling that the free exercise clause allowed the state of Washington to fund a scholarship program that excluded students pursuing a degree in theology. You submitted a brief in that case, unsuccessful, but I think we see the same issue coming up in other contexts now, and it makes us wonder whether Locke v. Davey is going to end up being confined to a very narrow realm.
Well, you'd think that like a brief that you wrote in a case where you lost 7-2 would not be a brief that you were that proud of. But I still think the SG's brief in Locke v. Davey was a fine piece of work. And I think if anybody wants to dig it up and take a look at it, it doesn't look that different from the majority opinion in like Trinity Lutheran or Espinoza, except there aren't as many apologetic footnotes. So I actually think it's, it was the right view then. Whether that remains a decision about Washington State's ministerial sort of scholarship program and remains, with this much precedential effect, or whether the court ultimately revisits it and formally overrules it, I don't know. But I do think, that's a case where at best, that decision over time has been limited to its facts. And I think the fact that that decision was 7-2, shows how much change there's been over time. But I will say, if memory serves, Chief Justice Rehnquist took the majority opinion in that case, and I don't think he believed a word of it. And that's a highly controversial practice where particularly a Chief Justice will take an opinion, and in order to keep it kind of narrow, Chief Justice Berger, I think, tried to do that without great success in terms of sort of shaping the law. But I think maybe we ought to all tip our hat to Chief Justice Rehnquist on this one, because Locke v. Davey, because of the way he wrote it, became a very easy decision for the court to distinguish in Trinity Lutheran and in Espinoza. And maybe with the composition of the court now, it wouldn't have mattered. No matter what it said, you could have sort of cast it aside. But I think particularly given the court that decided Trinity Lutheran, I think the fact that Chief Justice Rehnquist kept that case for himself and wrote it about as narrowly as he could, I think probably did bear dividends roughly 20 years later.
Great. And then in 2005, the court decided a case called Cutter v. Wilkinson. I believe you argued this one. This is a case that involved a challenge to our LUPA and an Establishment Clause challenge to our LUPA. And you weighed in on behalf of 5 prisoners, including, I believe, a Wiccan and a Satanist.
Indeed, indeed. This was a case that, so when you're the Solicitor General, you generally basically have the opportunity to pick the cases in a particular sitting. We pick one of those cases to argue. And in a typical sitting, at least back then when the court had a few more cases, there would be maybe a dozen cases a sitting. The government would have participated in roughly 10 of those cases. So in a particular sitting, you'd have 10 cases to pick from. In some sittings, the case that you should argue would just leap out. There's, if there was a Gitmo case or there was a case about the president's authority under some particularly important program, of course the Solicitor General should argue that case. But sometimes you had a little more opportunity to pick your case, and Cutter was one. I wasn't too worried that the court was going to strike down RLUIPA on Establishment Clause grounds. It seemed like at that point the doctrine had gotten to the point where there wasn't a great risk of that. But I really did want to argue the Cutter case myself. I'd actually argued the same issue in one of the lower courts. And part of this was, although RLUIPA passed, I think, a year or so after I left the Hill, the work that we did on the Hill, some of the hearings, some of the initial discussions, really paved the way for RLUIPA to try to replace RFRA to the extent it could. And so I felt just a kind of a special affinity with the statute and the opportunity essentially to defend something that I'd been involved in the very early stages on Capitol Hill was something I just couldn't resist. And it's a funny thing about religious liberty, right? I mean, sometimes there are doctrines that become established in cases involving very, minority religions that some of us won't even recognize as religions. But those cases are the building blocks for basic protections for religious liberty that end up protecting everyone, including majority religions. And I know that there are a lot of groups that are dedicated to litigating religious liberty that have kind of recognized this basic insight. In some ways, it's almost easier to win on behalf of minority religions, because if minority religions are accommodated, it doesn't sort of bring down the whole program or has this perceived threat to the whole program. And in recent years, and maybe this is a segue to cases like Hobby Lobby and Little Sisters, but in some ways in recent years it seemed harder to convince the court that they should accommodate plurality religions with sort of more adherence because it's more disruptive to other non-adherents that may be in the same workplace or the like.
Before we jump to the Hobby Lobby and Little Sisters, let me ask about the Ten Commandments monuments cases, both decided in 2005. These are split decisions, each 5-4, involving monuments. Well, I guess in Texas, there's a monument on the grounds of the state capitol. In Kentucky, I believe there were some sort of poster displays in courthouses. So I'm not sure those could be called monuments. Justice Breyer was a swing vote in these two cases. Curious, have any observations on these cases or his role, and also just how things have changed, if they have, say, compared to the recent Bladensburg cross ruling?
Well, to just say, as you did correctly, that in an important religious liberty / religious display case that Justice Breyer was the critical swing vote is to underscore how much the court has changed. And I think the case that involved the monument in Texas was a case called Van Orden. And Van Orden really did sort of pave the way for the Bladensburg Cross case. And it's possible that if Van Orden hadn't been decided, the Bladensburg Cross case might have been a little closer in terms of the outcome. But the fact that you go from Justice Breyer casting the decisive vote in, compared to the Bladensburg Cross, a relatively modest monument, to the fact that the court overwhelmingly sides with the people defending the Bladensburg Cross, just is another one of these like landmarks or hallmarks about how much the court has moved on these issues. But I do think it's worth pausing just to say just a thing or two about Justice Breyer, because one of the problems in this town that we've both lived in for the last 30 years is people are sort of so focused on what's next. And when somebody like Justice Breyer steps down, all the speculation immediately goes into who's going to replace him and what's her jurisprudence going to be like and all this stuff. That there probably is not enough of a reflection on the public service of the justice who's stepping down. And Justice Breyer was not a vote that I could always get in my cases, but he was a vote that you could sometimes get in surprising ways. And the Van Orden case really is one of the cases that stands out in my mind, because sometimes it's relatively easy to get a justice when they're the sixth vote or the seventh vote. But to get a justice to cast the fifth vote in a case that that is sort of would otherwise go kind of the way that you might expect them to vote, that's a pretty significant judicial act by that justice. And I think it probably, if you isolate cases like that, and Van Orden's one of them, you can really tell a lot about that justice and his or her jurisprudence. And in this case, what Van Orden, I think, really stands for is Justice Breyer was not inherently hostile in the religion cases, the way some justices on the left can be. And he was really, first and foremost, in this area of the law and in so many others, a pragmatist. I mean, he certainly understood the doctrine. He could write a doctrinal opinion if he needed to, but he was really kind of focused on the practical effects of the decision. And I think for him, there was a big difference between the Kentucky case, where some relatively recent, relatively small displays that probably most people didn't notice were put up on the walls would then be taken down from the walls to comply with this decision. He thought that was completely different than taking a monument that had stood on the Capitol grounds for a couple of decades without real objection.
1961, I think, yeah.
Yeah, and then taking the proverbial wrecking ball to it. Now, I suppose they probably would have not actually had a wrecking ball, but sort of the visual of this longstanding monument being removed from the Capitol grounds, I think he understood that people would perceive that as the hostility to the religion, that there's a lot of Establishment Clause cases that say that we're supposed to not have an established religion, but we're also not supposed to be hostile to religion. And that's usually just dictum that doesn't get applied. But I think in the Van Orden case, I think his vote was really impelled by this sense that you couldn't take down this longstanding monument without sending very much the wrong message. And I was reminded of this. I was talking to Kelly Shackelford at First Liberty, who was involved in the Bladensburg Cross case, and he reminded me that one of the Fourth Circuit judges had the brilliant suggestion that maybe they could take the arms off the cross and just slice those down, and then the monument could stand, and that would be sort of Solomonic justice. Probably not the way the judge put it, but the message of hostility that something like that, or taking down the monument on the Capitol grounds in Texas, would send, I think, is something that really resonated with Justice Breyer.
Let's talk briefly about Hobby Lobby, Zubik, and Little Sisters before we get to where we are and how you see the future of important matters like Smith and Lemon, and perhaps even the Hardison, the reading of the Title VII accommodation. I think you argued all three of these cases, Hobby Lobby, Zubik, and Little Sisters. And they presented different aspects of the so-called HHS contraceptive mandate, the regulatory implementation of Obamacare. I think this is really where we see full bore the stigmatization of religious liberty, the use of scare quotes, the notion that the Religious Freedom Restoration Act, which, as you pointed out, had been adopted almost unanimously in 1993 with obviously a bipartisan coalition, now was very controversial. State RFRAs led to boycotts. And you see the real clash between the religious liberty and the left's regulatory agenda.
Yeah, these are hard cases to discuss briefly because they're hugely important cases, and I really feel like I was just blessed to get an opportunity to be involved in those cases. I'm a practicing Catholic, so the opportunity to represent the Little Sisters of the Poor is about the best client I can imagine happening, and we'll see what the Biden administration's kind of next move is on these issues. But I think they would be well advised to figure out a way to give an exemption to the Little Sisters of the Poor, just so they don't have to. Biden v. Little Sisters of the Poor is just not a case where I'd want to be, sort of betting on Biden. So these cases were just a wonderful opportunity to get involved. But as wonderful a client as Little Sisters have been, I first got the opportunity to represent Hobby Lobby, and they were also an amazing client. And I got the opportunity to fly down to Oklahoma and to sort of see their facilities and see how they walk the walk on a daily basis. One of the things a lot of stores of a similar volume to Hobby Lobby do what's called backhauling. So if they deliver their goods from one store to another, they have essentially an empty truck. And so most stores will backhaul pretty much anything in order to save a few bucks. And they had a policy that they wouldn't backhaul alcohol. They wouldn't carry shot glasses in the stores because that was all inconsistent with their religious beliefs. So it was really just what great clients in these cases, and the clients in these cases really are the heroes. So I'm just so fortunate to get a chance to be involved in these cases. But as you say, Ed, these cases really show that it's one thing if you're representing sort of one religious adherent in a prison who wants to have a beard or something like that, and you're miles away from the agenda of the left. But if you get in these cases where the religious liberty claim bumps up to, free contraception, a woman's right to choose, issues of sexual orientation, that's where things are really getting hard in religious liberty cases. That's where the Grand Coalition has kind of completely broken down, and as you say, religious liberty starts being put in scare quotes as a synonym for discrimination, hate, whatever. And that's why these cases are so important, because the claim of religious liberty is hugely important. The cases, if you just look at them objectively, should be easy, frankly, because the idea in this area of the law is you can only force someone to violate their sincerely held religious beliefs and substantially burden that if it's the least restrictive alternative for the government to do that. And so the way that generally plays out is if you have a policy as the government where you really can't have exceptions just in the nature of the program, and taxes, for better or for worse, are a good example, then those are the cases where the government has a chance under strict scrutiny. But in a case where the government has already grandfathered, like thousands of employers and millions of employees for reasons no more, sort of substantial than administrative convenience, and they've given an exemption to some religious groups out of a recognition that this contraception mandate might be religiously controversial, but refuse to give it to other religious groups that are almost indistinguishable, that ought to be a case that's 9-0. And these cases have been a tough and long slog, and they haven't been 9-0. What I'll say is, to me, the most interesting thing about these cases, just as I was reflecting on it, is there was something about the religious claim here which was ultimately bottomed on sort of the idea of what makes you complicit in the actions of others, that for some reason judges, even a couple of pretty good judges, like Judge Smith of the Fifth Circuit, surprised me, his vote in this, but judges, I think because there's a very similar legal concept of complicity, responsibility, aiding and abetting liability, they were really like willing to kind of fly spec and question whether the nuns really sort of had this right. And sometimes they did it explicitly, more often they did it implicitly. And you put that next to a religious belief like transubstantiation, and it ought to be easier for the secular judges to accept the nuns' concerns about complicity than for them to accept transubstantiation. But the one they're willing to defer to, because it's so outside of their sort of compass, and the other they were perfectly happy to second guess. So that's always been an aspect of the case that kind of fascinated me and was part of why this was a tough slog to get it back up to the Supreme Court.
One last big question, or maybe two-part question here, the future of Employment Division versus Smith and Lemon. Lemon arguably has been marginalized into insignificance. Justice Scalia, of course, had his famous line comparing Lemon to some ghoul in a late-night horror movie that repeatedly sits up in his grave, and but explained that such a docile and useful monster is worth keeping around because you never know when you might want to use him. But it does seem that Lemon isn't a big obstacle now. Smith, I think, has also been hemmed in. There have been exceptions explicitly or implicitly. The whole notion of what constitutes neutral and generally applicable has been contested and developed. But I think it's fair to say that Smith, as we saw from the last panel, remains an important decision out there. Not much liked by most folks in this room. Others of us may wonder what the alternative really is. That, of course, came up in Fulton v. City of Philadelphia. But any closing thoughts on these two cases?
Sure. So, I mean, to start with, just to stick with our theme about the trajectory of the law here, I think when we were coming out of law school, like, you know, people did talk a lot about Lemon and Lemon being a terrible precedent, unworkable precedent, really needed to overrule Lemon. I'd almost venture to guess that when we were coming out of law school, you know, conservatives would talk about Lemon, you know, right below Roe as cases that really, you know, were wrong turns in the 1970s and needed to be reconsidered by the court. And people really didn't talk about overruling Smith at that point. And you know, maybe it's because it was a relatively recent decision, maybe because it was authored by, you know, the most, you know, seemingly conservative justice up there. And the fact that we've now got to the point where Lemon, although it's never been overruled, is arguably not very relevant, and, you know, now Smith is very much in the sights, does show kind of where the trajectory has been on these issues of religious liberty over the last 3 decades. I will say one other thing that Justice Scalia talked about in Lamb's Chapel, and it's maybe why that although Lemon isn't the problem it was 3 decades ago, it might be useful for the Supreme Court to finally sort of make it official, is that Lemon, although it really doesn't figure much in a typical Supreme Court Establishment Clause case anymore, if you're in front of a hostile panel of appellate judges somewhere, Lemon can still be front and center and still be the justification for ruling against a position that I think the Supreme Court would vindicate pretty rapidly. So there's something to be said for sort of turning square corners on Lemon. And then there's one reading of Fulton where, you know, Smith is not all that relevant anymore, because if Fulton is what it means for a law to not be, you know, neutral and generally applicable, then most laws are subject to strict scrutiny already. But there too, you know, I think that if the court just leaves it at that, sort of Smith will be out there. You know, the last thought just on Smith, as a Justice Scalia clerk who, you know, spent a lot of time on religious liberty issues, this is always an awkward subject. But the one thing I'll say in sort of limited defense of Justice Scalia, but also as to why maybe even he'd be willing to sort of think again, is that a big part of his concern, I mean, of course, part of it was a love for text, part of it was a love for bright line rules, but a big part of it was the concerns about the workability of sort of Sherbert and Yoder and how he perceived those tests would work in practice. And because RFRA came so quickly on the heels of that, and then RLUIPA also became a statute that's been applied by lots of courts. I mean, we've now had 2.5 decades or whatever it's been of courts applying heightened scrutiny in this context. And indeed, Justice Scalia had no problem when it was a statute applying that test. And so in a way that is almost unique in the context of considering stare decisis and whether to overrule cases, like the workability sort of argument should be off the table now. Because these statutes have proven perfectly workable. The sky has not fallen. And so I do think that that's one aspect of this where the world does not look the way it did when Justice Scalia decided Smith in all sorts of ways. I think Justice Scalia would be quite happy to have the colleagues that he would now have on the current Supreme Court. But one thing that doesn't look the same is these 25 years of experience with RFRA and how workable it's been in practice.
Wonderful. Well, thank you, Paul, for the enlightening discussion. I look forward to seeing how you shape the law of religious liberty over the next 30 years. Please join me in here.
Well, thank you so much. Thanks, Ed, so much for this inaugural co-hosting of an event with the Gray Center, and we're so thankful for Paul's time. In addition to his daytime job and teaching extensively at Georgetown, he's also joined the Gray Center recently as our Justice Joseph Story Distinguished Practitioner in Residence, and we are very grateful for their time. The Gray Center will be in touch soon about our next public policy conference on Capitol Hill in late May or early June, dealing with legislation in the administrative state, and thank you for joining us to discuss these very important issues today. Have a wonderful afternoon.